Is 10 a.m. and I'll call this meeting of the Board of Supervisors to order. The first item on the agenda is approving the agenda.
Make a motion to approve the agenda as presented.
I'll second.
Have a motion by Supervisor Jorgensen, second by Kiefer to approve the agenda as presented. Those in favor say aye.
Aye.
Aye. Motion's carried. Item 2, public comment. We're entertaining any public comments from anyone on agenda, on anything other than agenda item that's on our agenda today. We take public comment either in person or on the telephone line. Is there anyone that'd like to make a comment on the telephone line? Hearing none, we'll move to item 3, review and action regarding approval of the October 21st and 24th Board of Supervisors minutes. There's one change I would like to make. It's one word. In the October 24th meeting. Okay, in the paragraph, it's the first, second, third. The third paragraph. It starts off by saying, the paragraph starts off by Q and question Kiefer, but what I'm would like to have changed is one word in that paragraph, if you're following along there. Kewen suggested hiring outside counsel to review County Attorney Pritchard's opinion is unusual, but that we would want to hire one who could provide a fair and unbiased opinion, rather than one who was a proponent of an anti-wind and mentioned gravelly represented landowner groups opposed to wind turbines. The only word I'd like changed is unusual to unprecedented. And I have my notes that that's clearly what I said. I have a lot of notes to that effect. It's more than unusual, it's unprecedented. And that's what I said. I'd like that changed. One word from unusual to unprecedented. Does that require a motion, or is that something that you sent to the newspapers? How do you like to handle those things?
I believe you used both words in your talking about it. Originally you said it's about unusual, but then you did read your statement later that did use unprecedented. So it's, both are in there, so to be changed, that's up to you. I can change it. If you're all okay, the minutes just went to the boards or to the newspapers yesterday, and I could correct that and change that. Both words were used. One unusual was earlier, and you said you would get back to that later, and then you did say unprecedented in the later part. Whatever your pleasure is. Okay. It just went to the paper yesterday, so I can change it if that's true.
Does that require a motion that we
I could just change it right now and send it to you all so you have it, so that's what you're approving, if you're all good with that. Do you have any issues with changing that to unprecedented?
I don't, I mean, I don't have any problem, but I guess it was stated, it was, had both in there. I don't know, I really don't know what the difference would be.
anyway? Well, then we could perhaps solve that situation by saying unusual and unprecedented. Is that a fair compromise?
Sure.
Sounds good. Okay. All right. Make that correction in the minutes. Thank you. there any other comments about either the minutes of October 21st or 24th? Is there a motion to approve the board minutes?
I'll make a motion to approve the October 21st and October 24th, 2024 minutes.
I'll second.
All right, we have a motion by Supervisor Jorgensen, seconded by Supervisor Kiefer to approve the October 21st and 24th minutes. And Auditor Carr is just going to add the words "and" unprecedented to those minutes.
I've already emailed it to you, and I'm sending it to the newspaper.
Further discussion? Any comment from anyone listening on the phone? Hearing none. Those in favor of the motion to approve the amendment, to approve the minutes of the October 21st and 24th meeting, say aye.
Aye.
Aye. Motion is carried. Number 4, review and action regarding approval of claims.
I didn't see anything in the claims that jumped out to me to be unusual or excessive. I'll make a motion to approve the claims.
Second.
All right, we have a motion by Supervisor Kiefer, seconded by Jorgensen to approve the claims as presented. Further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Aye. Motion is carried. Item 5, updates on various boards, commissions, and activities since the last meeting.
I've had some communication with EMS Chair Keith Starr, keeping me updated on some things. No big changes, just how the process is going.
I attended VA meeting and also a cultural entertainment meeting at the Chamber of Commerce.
I attended a meeting of the FMC Governance Board and the FMC
Early childhood.
Early Childhood, yes, Board of Directors. And we talked a little bit about who will be replacing Floyd County on that Board of Directors after my term expires on December 31st. And I also talked a little bit about planning and zoning coordinator regarding the mapping. Some maps.
I did, yeah.
I think we'll actually be talking about that in future agenda items. I want to ensure that everyone has an opportunity to get input into what the agenda is for the meeting tomorrow night, the third reading. So we'll be talking about that specifically in future agenda items, that agenda.
Okay.
Item 6, which is a discussion regarding EMC insurance coverage for defending the county in a potential litigation regarding an ordinance amending Floyd County zoning ordinance regarding provisions regulating commercial wind energy conversion systems. Supervisor Jorgensen had asked questions about that at one point in time, and we had a conference call, Auditor Carr and I did, with our EMC insurance coverage provider. And there's kind of a lot to it, and Auditor Carr has taken some pretty extensive notes, and that's all in your packet of information regarding that possibility and those possibilities. Auditor Carr, would you like to kind of lead that discussion regarding those possibilities that we discussed that day?
Sure. So I originally initiated a call with Mark Melrose, who put me on to Zane Eller, who gave just some pretty generic, broad strokes conversation with how a case would be handled and what our insurance would cover a $2,500 deductible, and we have $1 million in liability. The questions I had weren't specific enough, so he said he had only been doing this type of work for a little over a month, and so he hooked me up with with David Habel, David is, I believe, working out of Pennsylvania, has been doing this type of work for over like 25, 30 years, something like that. And he was provided with the Worth County case, the ruling on Worth County. And so initially the call started out with that sounding very similar to what happened years ago with wind turbines. We said 25 plus years ago, nobody wanted wanted cell towers in their areas. And so there were lots of cell tower lawsuits filed against the cell phone companies, and the cell phone companies would purchase land, or they would either put it on their own land, or they would do lease type agreements. And a lot of people fought that. And that his response that was that nearly every case that was brought forward, the cell tower companies were the winners of those cases, not the property owners. So that was just one comment that he had. We talked about acting in bad faith, and does our insurance cover those activities of bad faith? He said that the bad faith is a hard thing to, usually you don't know if something's been in bad faith until you've gone through a trial. And then there may be some bad faith. So we have our linebacker policy that I've included in here that he referenced, that we could be potential bad faith efforts there. But he said we would be covered with our $2,500 deductible and our, because of that policy that we have. So that wasn't acting in bad faith. Like an initial lawsuit like this wasn't anything they seemed to be concerned of. The policy does cover for defense, and because we have supervisors on opposite sides of this, it could be that they would have to provide defense for both sides. So potentially there could be, if we are sued, there could be, our insurance would procure an attorney for Jim and Dennis's position, and then an attorney for Mark's position, which would likely be the same attorney that would defend the county otherwise. So it wouldn't be that we would need 3 attorneys, likely could be 2. We did talk about how we have changes in positions coming up, with Jim being done mid-November. So he said, you know, worst case scenario is there could be multiple attorneys that could be hired to defend whosever position is out there. So whether it be Boyd's position and pending when things are done, or my position if I'm in office in January. It is just one deductible for however many cases there are, or however many supervisors they're defending in a case, should the supervisors be sued. But then also, if there are lawsuits such as we brought up Scott Hines, who has that 1,260 contiguous acres, and pretty much contiguous acres, that he said if the county doesn't go through this, that he will sue the county. He intends to sue the county. That's still the same $2,500 for the deductible on the case. However, and I'll probably just read, I might just read all this part just to make sure I've got everything correct. Coverage for defense may need to be separated out if the board members are not on the same page. It could cause a conflict for whomever EMC decides to defend the county. In that case, they would assign separate attorneys, probably one attorney for the 2 supervisors who voted one way, and a different attorney for the other supervisor who voted the other way. That way it would keep everything from getting all jumbled together. The county would not likely need a 3rd attorney unless there was a conflict between the 3rd supervisor. There would be no separate deductible if there were other attorneys. If different attorneys are needed to defend positions, EMC will provide coverage for both and fight for both. If that be the case, discussion on the topic is only between attorneys, not the individual supervisors. Supervisors will could say they don't want EMC to represent them. If so, they pay for it themselves. A newly seated supervisor could also be named in a suit. Exiting supervisors also get defense. Our policy has a $2,500 deductible and a $1 million liability limit. No matter how many claims are filed, it is one $2,500 deductible. The $1 million liability limit is different if monetary or non-monetary damages are applied. If the wind company is looking for the ordinance to be overturned, but not money other than plaintiff attorney fees, then all the defense costs would eat away at those limits. If they are claiming covered monetary damages, the defense would all be above the $1 million limit. There is a land use exclusion on the linebacker policy. EMC would defend as long as it has something to do with zoning or permitting activities. But if it was a claim considered as a taking, either by the landowners or by the wind company may have a claim, you would have coverage for defense, but there would be no coverage if it was determined that the county deprived them from making money off of their land, deprived them from making money off their land. That would all be on the county. If there is any award for the loss of use of their land, those damages would not be covered by our policy. The public officials / linebacker policy covers defense, but also covers the plaintiff attorney fees. The plaintiff can claim whatever they want. Example, 30 years of lost revenue, but EMC cannot address this because they do not know what would be alleged. The big claims may come from landowners rather than the wind companies. And I had mentioned to him that one of the 86 landowners who had signed easements has the 2 sections of contiguous property that said if he was denied that because of our ordinance, his threat was that he would sue. Allegations are reviewed by EMC, and then the policy is reviewed, and then EMC would send a position or a reservation rights letter on what is covered and what is not covered. EMC cannot send a letter until they know what is alleged. Dave understands the county is being proactive and trying to head off a lawsuit. If the county wins a case and the plaintiff appeals, EMC would defend the county. EMC would stop defending if there was a court of law ruling against the county that the county wants to appeal. There is language in the policy that the county would be on their own for defense. So if we lost a case like Worth County lost, and if we were to appeal, which we don't know if Worth County is appealing or not, EMC would not stand behind us for that appeal process. When you start filing appeals, the same legal counsel that EMC provided could be used at the county's expense, or the county could seek their own counsel. When you start filing appeals, you have to make sure you have the right set of facts to appeal. If you don't, you're going to set bad case law. You really have to look at it if you want to appeal it, because if you lose, it becomes the law of the land. If a ruling came out of a lawsuit with Floyd County, like was Worth policy, I provided the linebacker section in here that said that they will not be defending us on an appeal. That was about the justice.
Go ahead, if I can.
Yes, Chair recognizes County Attorney Richard.
After Thursday's meeting, I had a discussion with some of the attorneys that represent Worth County. They talked about some of these issues that they're now dealing with, and so he estimated, and it's documented from Madison County, that they estimated that the damages could be extreme. What's our liability then if we were to get?
No.
We're only covered up to $1 million. That's a fraction of what Madison County, right, their damages might be also significantly less than what.
So I sat in that discussion that we had with the MC providers, our insurance providers, and just an overview of some of the takeaways. I know you covered them there, but there's one 2,500 deductible, no matter how many lawsuits are filed. The supervisors could be represented by more than one attorney, is that correct?
Right.
And the incoming supervisor or supervisors in this case could be included in any claim or any lawsuit,
Could be.
could be.
Yes.
And in our policy with EMC, if the county lost a case against us regarding our ordinance, then if the county chose to appeal, EMC would not cover those costs.
Right. Correct.
How about what I recall from that conversation was they were very concerned about the landowners' lawsuits as well, and stated that those could be very damaging. Said we had during the third reading, we had a landowner threaten a lawsuit to that effect. So is the $1 million in total or in each one of all of these?
Total, because it's still all the same. Though it's different cases, my understanding, and I can ask that question more, but my understanding is that just like the deductible, you're gonna pay one deductible, because it's all associated, you're only gonna have $1 million. I believe that's the way it goes. I can clarify that.
So even if one of the wind turbine companies wouldn't file for damages, the county could still be liable for damages on a lawsuit from any one of the landowners.
Yes.
Any questions, comments from any members of the board?
I don't have any, I appreciate it.
Chair,
Yes, Chair recognizes, who is it?
it's Isaac Lampa.
We're gonna turn up the owl a little bit to make sure everybody can hear that. So, yeah, thank you. Identify yourself again and you'll be recognized.
Hey
Yeah.
everyone, can you hear me, Brent?
Yes, we can hear you, Isaac.
Awesome. Hey, Isaac Lampa, project manager for the Marble Ridge Wind Project for Invenergy. Just heard Auditor Carr's statement on just the county trying to avoid any sort of lawsuit. Wanted to step in and just say that, in good faith, we'll be, voluntarily accepting any additional restrictions within a development agreement through a letter that I sent late last week. And I was wondering if the board had reviewed that letter at all, or those drafts of those agreements, just to see if we could, have an opportunity to try to negotiate and avoid any litigation.
Yes, that email arrived at 11:15 a.m. on Thursday. It had 4 attachments. And yes, I did get to review those. So they're making another offer to negotiate and willing to do so prior to any final reading of the ordinance. All right, thank you for that. Any other comments regarding insurance coverage? All right, I think that's important to know as we move ahead. Thank you. Item 7, discussion regarding Attorney Thomas Reveley review of the ruling of the district court case Worthwhile Wind LLC versus Worth County Board of Supervisors and how the ruling may impact Floyd County if the Board of Supervisors approves the current proposed wind ordinance amendment set for consideration at the October 29th board meeting. Last week, we did agree on a letter of an attorney-free fee contract. And at that time, Auditor Carr sent Mr. Reveley a long list of documents, including past Board of Supervisors minutes, the case, of course, in Worth County, our county attorney's opinion regarding that. And there's a lot of things to review. And at that time, we had agreed that Mr. Crowley would provide a written review to the client by 9 a.m. this morning and be available by phone or Zoom to participate in the meeting at 10 o'clock today. I got to meet Mr. Reveley this morning and told me he does not have a written opinion, but at this time I'll recognize Mr. Thomas Reveley. If you would please, yeah, great. We can hear you better if you address this from there.
Thank you. Originally, it was requested for me to have a written opinion this morning by 9 o'clock. I did receive the documents, although I was in North Carolina all of last week, and I got back in the morning about midnight Saturday night. The reason I don't have a written opinion is that I have it dictated, and I was going to have it typed this morning, but the more I thought about it, I think that there's some issues there that I think would be better in terms of an attorney-client privilege to have a closed meeting for anticipation of litigation. Now, I just told your county attorney I was going to request that, and he may disagree with this request, but I do think that pursuant to the September 16th, 2024 letter from Brown Winnick and all the other documents that I have reviewed, I do think it's important for me to be able to sit down with the board privately as an independent attorney and go over issues and paths forward in this, problem. So I can address the Worth County opinion. Of course, it was adverse to Worth County, but each one of these issues is fact dependent. We talked about the Madison County. I was involved in that Madison County litigation. Now, I wasn't the attorney for the insurance company for Madison County. I didn't obviously represent Mid-America, but I was an interested party on the pleadings, and I know what happened there. And I know the facts in that Madison County case. And that is the reason I say that each one of these issues is fact dependent. You have to look at what was done and what was said, by whom, at what time. You have to get a specific chronology together, and then you have to verify, because it's real easy for the energy company to come in and say, oh, we've spent millions of dollars doing this, millions of dollars doing that, but it's just on paper. You don't know. And so what do you do when you're faced with this? What are your options? And I think that is one thing that I think is important to have an attorney-client relationship for my advice to the Board of Supervisors at a closed meeting in anticipation of litigation. I just mentioned that to your county attorney a few minutes ago, and he may disagree with imminent litigation, but I think you're going to have litigation in this case, one way or another. And you've been threatened with litigation. And so I think it's important for me to be able to sit down with you privately, and that's what I'm asking for.
When we discussed that issue, we discussed that at length regarding Samantha Norris's letter to the board.
Right here, yeah.
And at that time, the county attorney Pritchard advised us that litigation was likely but not imminent. And one of the 12 exemptions that is provided to boards of supervisors or public bodies to go into closed session. You have the handbook. We'll read that. It was discussed at length whether or not we should go into a closed session. And the reason given and the reason we relied on was item C, to discuss strategy with counsel in matters that are presently in litigation or where litigation is imminent, where its disclosure would be likely to prejudice or disadvantage the position of the government body in that litigation.
I think we fit that because particularly what she said a few minutes ago, that you have a landowner that's told you that he's going to sue.
He's made that statement during a hearing, but
Yeah.
and as far as the question about what was called the saber rattling by our county attorney of the letter that we received from Samantha Norris of Brown Winnie, there he checked the court records. There was no court, nothing filed.
No, there is.
So we did the ruling that he gave us and we followed was that there wasn't anything imminent. It was likely. In fact, during that letter, Samantha Norris also issued the ability to negotiate with the county at that time.
That was the last paragraph. That's what she said in the last paragraph.
The request to go into closed session was thoroughly discussed at that time. In fact, at one point in time, Supervisor Kiefer suggested that we just go into closed session anyway. And regardless of the fact, and that would actually violate the Iowa Open Meeting Law. Supervisor Jorgensen asked if we could table this discussion until we actually had actual litigation, and we decided not to do that as well. So your request to go into closed session is most unusual because you entered into agreed to a contract with us to provide us an opinion at this meeting, a written opinion, and now you're saying that you think we need to go into closed session. We certainly can't go into closed session today.
That's true.
Because it's not on our agenda. So we are going to discuss what you have to tell us, if it's either written or not, in open session, because tomorrow is the third reading ordinance. There's no time to have another opportunity, another bite of the apple, if you will, to go into closed session with you.
Well, you could do what you want to tomorrow, and then depending on if anything was said in the closed session to change your opinion, you could go back and amend something. I mean, that's been done before. There's no problem.
I have no desire to go into closed session with you. You are not our legal counsel. We hired you for your opinion on the Worth County ordinance, Worth County ruling versus worthwhile win, but you don't represent us as our legal counsel.
That's true.
And County Attorney Pritchard does.
I understand that.
So, one, we can't go into a closed session.
All right.
We don't have it. The ability is not to do that. And I would stand by County Attorney Pritchard's advice that it's not legal to do so. So if you care to discuss with us what you've learned since you returned home from North Carolina yesterday, feel free to do so.
Well, I will have a written opinion for you tomorrow morning, 9 o'clock. And I don't really think that's a proper way to go, because I think there's some options you have that it's in the best interest of the county for you three to discuss your options. I can discuss it with your county attorney too, but I don't think that I know I'm not your legal counsel. I was hard to give you a legal opinion, and I will. But I decided not to have one today because I didn't want to pass it out to everybody and have it in paper, because I think there's some things in there that you should consider privately, because I do think litigation is imminent. But I'll have something to you tomorrow morning.
And do you expect us to consider that at some point in time?
Well,
We're
you can read it.
We're meeting tomorrow evening at 6:30 for
Yeah.
the third and final read of the ordinance.
And you can have it
Why
tomorrow
should
morning.
you haven't met the goals of what you agreed to previously. On the phone last week, you said you'd come home, you'd review all the documents.
Which I
that we
did.
had sent you, and you'd offer us a written opinion. You haven't done so. And now you're telling us that we have to go into closed session. And now.
And that's
the fact
my
that
opinion
we're-
after reading all the documents. That's right.
We're not going into closed session. You're telling us you're gonna give us your opinion tomorrow at 9 a.m.
Yes.
Well, good luck with that. I might ask one question at this time of you. Today, right, it was today.
Yeah.
The attorney fee contract that we signed with you.
Yes.
Stated, that you would charge us $300 an hour.
That's right.
For billable hours. To
That's
this
right.
point, at this time, how many billable hours do you have that you can charge the county with?
Well, I was in my office yesterday for 2.5 hours, and I drove up here 3 hours, 5.5 hours.
And you haven't really done any research on the opinion yet.
Yes, I have. Two and a half.
Yeah.
I told you, I was in my office for 2.5
That's good.
hours.
And so you have it, it's ready to be dictated, but you don't have it.
That's right. Because I didn't want to pass it out. I didn't want to make it public. So I thought it was in your best interest to go into a private session and discuss it.
Yeah, we've already discussed that you're not our legal counsel. In fact,
I understand
that, you know, we hired you to do one thing and you're not doing it. So, have any questions? We have a gentleman, chair recognizes Jim Davis.
Thank you all for your public service.
Make sure you come up here so we can hear you on the call, Jim. Thank you.
All three of you, thank you. I've had lengthy, sincere, respectful conversations with all three of you. And we've shared each other's point of view, even though I'm for wind farms. I was involved 20 years ago when Mid-American came to this community. They came here for one reason. They wanted to make a profit. They're a business. They also wanted to be good neighbors. They wanted to comply with the zoning ordinance, which is in place at that time. They've been a benefit to Floyd County taxpayer for decades. They've been a benefit to some farmers. Okay, it's a new world. We need to look at updating our ordinance. And let me say this, I served on the city council in 1979. I learned the difference between a resolution and an ordinance from Roger Ott, the city attorney. Like you guys, I have the whip marks on my back from doing that. That's why I applaud your public service. But I looked to Roger Ott at that time for a legal opinion. He's a lawyer, okay? But the second thing I looked to him for was, give me some practical advice on whether this is a good idea or whether it is not. Okay? I've been coming in the back door of that building and going up to the supervisors since 1977. Nobody in this room has come in that back door more than I have. Okay? And you all know I was an abstractor of titles. I debated with lawyers over every single word in the Iowa Code. Okay? So here I am today. And here's what it all boils down to me on what we tasked Mr. Eagley with. The Worth County opinion, the ruling. Okay? We've all read it. But it comes down to this, and this is what we tasked Mr. Eagley. The very last paragraph, and it's short. Orders. In accordance with these findings and conclusion, the court grants the plaintiff's petition and declares that the plaintiff has vested right to complete development of its commercial wind energy system project in accordance with Worth County law exists before resolution 2021.04.05 moratorium and Worth County ordinance 2022-0627 new ordinance. Costs to be assessed against the defendant is so ordered. That's the key question in mind before us today. I would have been hard pressed in '79 to tell Roger Ott I didn't like his legal opinion. I would be hard pressed to have Roger Ott give me practical advice on what to do and disregard it. In all my years being involved in this kind of stuff, I've never seen a position like this taken by elected officials. So I ask you to stop and consider where you're going with this. And once again, thank you for your public service.
Hey, Chair recognizes Samantha Norris from Brown Woody Law Firm.
Thank you for the opportunity. Just want to reiterate what Isaac said and what we've been saying since we've been coming to these meetings. We do want to work in good faith with the county. I think he offered up the notion of a development agreement or negotiation when the Planning and Zoning Commission was undertaking its review. That is contained in our letter. That is there for a reason. We do want to. And also, you know, in the group of documents that Isaac sent over, that was done in good faith to show the county what the development could look like, and there was movement from the planning and zoning version to that. So it was not, you know, done in anything other than good faith to show movement and you know, the willingness of the company to work with the county. So I do dispute council's take that litigation is imminent. We have made these offers in good faith and we've made them for a reason. It is not imminent. We do want to work with the county and we hope we can reach a resolution on this. Thank you.
Thank you. Comments from either members of the board regarding Mr. Revelle's statements today?
Oh. Yeah, I think feel that imminent is a possibility, especially with private land. That almost, I think it warrants a full session to get a clear understanding of what he wants to share with us. And it is in the code book. eminent will allow closed session.
When County Attorney Pritchard returns to the room, we'll ask him if he believes the landowner's statement that he made during the third reading of the ordinance is an imminent lawsuit. We can ask him. Anything else you'd like to comment on?
Anything at this time?
No, I don't either. Mr. Reveley, well, comment I made, is Mr. Reveley didn't have a whole lot of time to review this information. He was gone last week, but he did, and I respect his desire to go into closed session to discuss it.
I'd just like to comment, I know we've spent a good deal of time talking about Mr. Reveley's past experience. I know when you hired him, you said you didn't know some of the cases that he represented. I asked you if you looked up on the internet to see who he has represented in the past. He today spoke about his representation in Madison County. Have you, either of you, done any research regarding Mr. Reveling's background in this field?
What issue? Madison County?
With the issue we're talking about, which is wind ordinances and where he stands and how he has been involved in past cases.
I know based off the internet, he wasn't involved with the Madison County.
I was told the person he's involved in Madison County. And he admitted this morning he wasn't their attorney, but he was involved in some capacity with that.
Well, I think we need to clearly identify that capacity because there's a long list of things that I found when I started researching Mr. Reveley's background. And so if I may, I'm going to cite some of those things for you. So you have a better understanding of the person that you hired to provide us legal advice.
Can you wait till he comes back in?
If he comes back in, that's fine. I will welcome him to hear what this is a matter of public record. He can come back in the room, that's fine. Call him back in if you like.
I don't know where he's at.
I'd like to just make a quick comment
Go
about,
ahead. Chair recognizes Jim Davis for the second time. Go ahead.
I oppose going into a closed session. We're spending taxpayer dollars, let the light shine in.
Is Mr. Reveley out there?
Check that one.
Apparently he's left the meeting.
There's this bag right here.
He's welcome to come back, but I'm gonna continue with what I know because this is a case law.
Is there any other agenda item you could go to and then come back to it?
Sure.
Yeah, Todd's voicemail, so I'm not catching him.
We'll wait for him to come back. It's gonna be a rather lengthy list of involvement. Is someone getting him or is he talking to someone?
Try calling Todd and Todd doesn't answer and. Oh, there's Todd. You guys ready to come back in?
Is Mr. Reveley in the room or waiting outside the hall?
Right now.
What?
Waiting to come out of the restroom.
Oh, he's coming. We'll wait for him.
We were just chatting.
Are you ready to come back in or are you to plan on talking about outside of the room? Outside of the room? So they're gonna chat outside of the room. You wanna go on just come or something? Keep things. Can you-
Okay, we will do so, but he's coming back in because we need to discuss his past history and his involvement in, certainly in Madison County. So we'll just take a break on agenda item 7 and wait till Mr. Reveley returns so he can hear and comment on his past involvement in issues in the state of Iowa. Item 8 is review and action regarding a safety action plan for SS4A grant. Yeah, thank you.
So basically, as a part of our safety action plan that we've been in development with Kimley Horn, there's a pledge that they would like us to sign as a county. I think we got it sent out to you guys.
Yeah.
Basically it's pledging that we're going to be working to actually implement this plan and to work toward zero fatalities and making our roadways safer in Floyd County. So that's kind of the gist of it. More background on this is the Safe Streets for All grant program. 97 counties applied for it together to get safety action plans written from a consultant. So we're part of those 97 counties, and the safety action plans are just getting into their final forms. Basically, we had a meeting to go over the drafts of them. I had some suggestions for the consultant to change, maybe some different curves or different intersections that they could identify that needed safety improvements. So they're gonna identify 10 segments of road, 10 intersections and 10 curves and then they're gonna also identify different safety measures we can do to make these better. So then in the future, what I can do is when we have this safety action plan, we can actually apply for safety funds to do the projects that they've listed out, which would be a federal discretionary grant, similar to like that raise grant that we did for the bridges this last summer. It's not the exact same process, but somewhat similar. So this pledge is basically just showing our support that we're trying to make our roadways safer and have less serious injury and no fatalities is the goal.
What part of the County Engineers Association, or who are we pledging that we're going to make the safety strategy work?
Yeah, it's part of the County Engineers Association, our ICEA Safe Streets for All grant application. Basically, it's part of that. So because we did it as an association, and it's something we're going to be working toward always. We're always be working towards zero fatalities. That's the stance the DOT has taken, and it's the stance the counties have taken as well.
So you identify curves, intersections that you want to pay attention to notice. When do they come back with that information? How long does that take?
Shortly here. I think we should have the final version of the safety action plan, I think before the end of the year is the plan. Because the first opportunity to apply for funding will likely be released in February. So I would like to try to get a plan together to go for funds this winter is my intention. And the other nice part of this is we already have the safety action plan, so I don't necessarily have to get I don't think I have to get a consultant in line to try to write anything up. I think this is the write-up, so we've already got the plan and we can just use it as an application, and I have to specify the projects, which obviously is in our wheelhouse, so, yeah.
Any other questions?
All right. I'll make a motion to approve the safety action plan for SS4A grant.
Second.
We have a motion by Supervisor Kiefer and second by Jorgens to approve Floyd County Safety Action Plan, 5-year strategic highway safety plan for 24 to 28, with the overall vision of zero fatalities on Iowa's public roadways and those in Floyd County. Further discussion? Any comment from anyone listening on the phone line? Hearing none, those in favor of the motion say aye.
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 Aye, motion is carried. Move on to item 9, review action regarding repairs that need to be done in Drainage District 16.
So Drainage District 16 is just north of Charles City. I guess it's not a very large district, but basically it's all around Shadow Avenue there. There are 2 holes on either side of the road on Shadow. One's in section 1 and on either side of the road, one on section 1, one on section 6. Tim thought that's something that we should be able to get taken care of fairly quickly. I know the property owner was wanting it, I think, done sooner than later. So, but basically just 2 blowouts. Should just be 2 easy tile repairs.
I'll make a motion to approve the repairs that need to be done to drainage district 16.
Second.
I have a motion by Supervisor Kiefer and seconded by Jorgensen to approve repairs done in Drainage District 16. Is there a mountain roads?
No, we'll do, we'll get, the work order put together after we've done the work, and then I'll bring that back to you guys for if you need an assessment or not.
All right, very good. Is there further discussion? No. Hearing none. Is there any comment from anyone listening on the phone? Hearing none, those in favor of the motion to approve the repairs in Drainage District 16, say aye. Aye. Motion is carried. Item 10, review action regarding appointment to magistrate appointed commission. We have an application in your packet from Jay Jung, who is interested in serving on the magistrate appointment commission. Perhaps you know Mr. Jung, if you've seen his application.
Yeah, I know Jay, I've read his application. Make a motion to approve appointment of magistrate, approve Jay Jung to the magistrate appointing commission.
I'll second that motion.
All right, we have a motion by Supervisor Jorgensen, seconded by Kiefer to approve Jay Jung to a term of, how many years are those terms, Brother Carr?
These are 6-year terms, and this one would be the remainder of our closest term. And the remainder of that
He send them to me.
term.
We're on
Yep.
one page.
All right, for the remaining term of Barbara Force, who has resigned from the commission.
So that will be through December 31st, 2026. But they're 6-year terms.
Those in favor of the motion, say aye.
Aye.
Aye. Motion's carried. No personnel changes. The retirement of FMC Early Childhood Iowa Area Director. I was there at the meeting the night that she gave it to us, and having been part of this entire process since I served in the legislature when we created the ability for counties to organize and to achieve these goals, I know how dedicated Lori Christensen has been to this work, and we're certainly going to miss her. She's provided wonderful leadership through a changing environment, and again, she's a valued resource to all the children in Floyd, Mitchell, and Chickasaw counties. So we'll note her retirement reluctantly, and we wish her the best in all her future endeavors. Also, we have a resignation letter from from Chelsea Wood. Chelsea, writing to formally resign from her position as Floyd County effective November 7th. She states she wants to express her gratitude for the opportunities I've had during my time. I've learned a lot and truly appreciate the support. She is a part-time employee, part-time in both the county auditor's office and the county attorney's office. Resignation is in your packet effective November 7th. Future agenda items.
I just like to say, just add to that, Chelsea has, after she was hired here, their city administrator, city clerk resigned, and she has accepted the city administrator, city clerk position. Quite a significant pay increase, we can offer.
Charles City, City of
North Springs.
North Springs.
Where she worked, where she came from.
Do you have any future agenda items to consider?
I don't this time.
I don't have anything right now, yes.
Earlier, I mentioned that, of course, tomorrow is the continuation of the third reading of the ordinance at 6:30 PM in the EOC. And I wanted to give all members of the board the opportunity to discuss, to put something on the agenda for that meeting. That agenda will be set shortly after this meeting, where part of the car and I will be going over that. But I want to give you the opportunity to put anything on that agenda that you would like. Is there anything you'd be interested in discussing?
Wouldn't it be the same agenda, just a continuation?
No, the agenda is not the same. The agenda is made differently. We've certainly had a lot of things happen since the last meeting. And we're discussing one of those currently. So the agenda will be put together after this meeting. I'm just asking for your input you might want on. One of the things I'm going to suggest, I know Supervisor Jorgensen, you talked about those maps. I think you held up a map.
Right.
Of the 1,000-foot
Waiver.
And so I know our Jesse Williams had put together that map for you. So you can expect to see that map. You can expect to see that map with all the other setbacks that are currently in
The overlays.
so we can look at it individually and as a result of what we're doing today. And I'll also expect to see a map of the ordinance that's in effect now. What's in effect now, which is basically 115% setback from homes, property lines, and public utility lines. And so how much of Floyd County is available for a wind company to develop, given our current ordinance? Because indeed, as if you've been following along, the Worth County ruling says that if it's not appealed and overturned, that is the ordinance that will go into effect. And so all the people who are concerned about wind turbines need to know, is that something that we should consider? I certainly think it is. So you can expect to see that one as well. Anything else? Anything else you'd like to see?
I guess not. I can't add to it now.
There's a map that shows different setbacks for eagles. Is that right? There's one with 5 miles and 3 miles.
Right.
Are there like 2.5, 1.5 mile maps?
I only requested 5 and 3.
We already have those. We've got those. We have for some time.
Yeah, I guess I can't think of anything right now.
All right, then, that agenda will be forthcoming shortly. Back to item 7, discussion regarding Attorney Thomas Reveley. Is Thomas Reveley returned from the restroom? Is he here?
They're talking next door in the conference room.
They're wrapping up.
What?
They're wrapping up.
Yeah. Well, thank you, Mr. Reveley. We're back to agenda item 7, and we're continuing our discussion that we started last Wednesday, I believe, regarding your qualifications and what your involvement has been in wind turbine issues in the past. And I did some internet search, and I found that you've been quite involved in this wind turbine issue in many Iowa counties for a number of years. So I'm just going to report to the board what I found. All right. Very good. In 2019, you represented a person named Sienna Rollins in her complaint to the Iowa Utilities Board against Mid-America's wind turbine project in Adair County, that case was dismissed. In 2019, you spoke on behalf of the opposition group entitled Cassuth County Citizens for Rural Property Rights at a meeting of the Cassuth County Board of Supervisors in opposition to the Cassuth Wind Energy Project. The group is very vocal in its opposition to wind farm developments in the county. In 2020, you appeared in Page County for an anti-wind conference where you spoke to county residents about the danger of signing wind turbine leases. There was a lot of comments that you made regarding that, and something I came across. Probably more important and relevant to the discussion for today is your involvement in the case Madison County Coalition for Scenic Preservation, LLC versus the Zoning Board of Adjustment of Madison County.
That's right.
And you were the attorney for the appellant.
Yes.
Mr. Rutland was the attorney for this group, and I think it's important to note that case and how that resolved. So just a little bit of background on that. I think it's important. So bear with me.
You missed Hancock County.
Huh?
You missed Hancock.
Well,
County.
tell us about Hancock County
Well,
first
that
of
was
all.
against Florida Light and Power, and that was quite a few years ago. I've got 2 cases pending in Ida County against Mid-American. I've got cases pending in Adair County. So you missed them.
Well, thank you for bringing them up. I think it's pretty obvious based on your case history and your comments here today that you could be categorized as an attorney for anti-wind advocates.
No, that's not correct.
Why not?
I belong to over 30 environmental groups. I am considered a very active environmentalist, and I think wind power is essential. And in fact, I've traveled all over the world. I've seen the wind farms, between Copenhagen and Sweden. And I am not anti-wind. What I am against is where they place it. Because I have clients one client who actually had to leave their home and abandon their home because of the problems with the turbines. I've had people have to move into their basement because of flickering and shadowing and the noise. I could go on and on. I have another client whose cattle, pigs, have reproductive problems because the veterinarian feels it's because of the wind turbines. I am not anti-wind at all, but they have to be put in the proper place. And that is the reason that I'm very, very concerned about setbacks and about people being able to enjoy their home. So
Thank you for that clarification.
So you can characterize me any way you want, but I mean, I'm not anti-wind.
All right, well, let here recognizes other attorney.
I just have a question. Since you're engaging with the county in this review of our ordinance, would that prohibit if we do have people who file a suit against the county, from you representing them? So if down the road there's lawsuits and anti-wind people participating or non-participating people come to you and say, hey, will you represent us? We want to sue the county or whoever. Does this engagement that we have with you mean you are not able to represent them?
I have to look at that more carefully, but since Floyd County right now is a client, I would say yes, it would prohibit that. You get conflict. Okay, conflict. Yeah.
Yes, chair recognizes Jim Davis.
Sir, I suppose you have gathered your thoughts on reviewing the one paragraph order from Judge Wheeland. Gathered your thoughts, and you're going to reduce them to writing now.
Well, I mean, basically what I wanted to say in this written opinion was the fact that everything is, these type of cases are fact driven. Now, I was a little uncomfortable getting back from North Carolina at midnight Saturday night and feeling that I had the entire set of facts to support a written opinion. Now, I could obviously do a written opinion on what I had at my disposal, but you have to be very careful because this is an important decision for the county. Now, the only reason that I'm concerned about the Worth County decision, it is certainly factually different. I mean, there's so many facts that are different. There's so many facts that are different between this and the Madison County case. But it is a recent case. And district court judges look at recent cases. And Judge Wyland, who I know very well, I've been in front of her many times because I do a lot of work up in this area, east in Hancock County. And she's a good judge. People respect her. So you gotta be very careful. And in that opinion, it states that I think on 2 occasions, maybe 3, that the parties got together to see if they could come to a resolution. Now, I don't know what the other side is proposing, but I've always been, well, let me retract. I've been doing trial work for 54 years. I have the distinction or whatever. I think trying the longest court case in Iowa for 6 months in federal court in Des Moines. I know what litigation is. I know how stressful it is. I know how expensive it is. And I know that you can't, with any certainty, anticipate or guess what the outcome is going to be. I used to tell my client, I can't say this anymore, that the only form of legalized gambling in Iowa was a jury system. I can't say that now. So I used to tell people, I have an inclination because I've been involved in so many lawsuits, in fact, 23 states, that I always like to try to sit down and see if there's a compromise or a resolution before you step off the cliff. So what I wanted to say in private, I'll say it now, is that I do think that my recommendation would be to table that resolution tomorrow night. And I thought differently yesterday. The more I thought about it, it's a table that and see what the wind people say and see whether that can fit in anything you're comfortable with. If you're not comfortable with it, then you end up just like Worth County. Worth County, they didn't get together, so they went to court. So that's my recommendation.
So, Mr. Riley, now you told us earlier that you had a written opinion.
It's dictated, so it's recorded, but it's,
You were going to present to us tomorrow morning.
I can have a secretary. She was
And
gonna
now
come in.
you've changed your mind.
No.
You're saying, well, you are. What you just said was now you're making a new recommendation.
And that's not a new recommendation. It's the same one
Well, then just repeat what you just told us, because I believe I heard that you said that you have now decided that you wanted to table this consideration of this action.
I don't care if you vote on it I'm just saying that I think you should sit down and talk with them, and that's exactly what is on my dictation. My recommendation. Now, when you do that, you can pass it tomorrow night and then discuss it with them, or you can table it. There are options. I believe in options. It's up to you.
That's good. I know when I was looking up your history, that's not totally unfamiliar with what you did in a moratorium situation where you said that the length of a moratorium in one of these cases that you've been involved in. It should be reconsidered. So have you finished now? Or
I'm finished.
I'm going to talk to, I'm going to review this Madison County Coalition for Scenic Preservation case versus the Zoning Board of Adjustment that you were in as the attorney for.
That's right.
Madison
One
County.
up before with you.
Yeah. So, in that case, Mid-American Energy sought and obtained permission from the Zoning Board of Adjustment of Madison County to build a wind farm with 52 wind turbines in Madison County. The Madison County Coalition for Scenic Preservation, whose attorney is Mr. Reveley.
Yep.
Petition for a writ of, how's that word?
Certiorari.
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 Certiorari, it's a tough one for me to say, thank you. Challenging the board's approval of the wind farm.
That's right.
Alleging the board's approval violated provisions of the Madison County's zoning ordinance and was therefore illegal. Following a remand to the board for expanded findings of fact and conclusions of law, the district court concluded the board did not act legally and annulled the coalition's writ.
That's right.
Strike one.
Mhm.
On appeal, the coalition, represented by you,
That's right.
challenged the court's interpretation of the ordinance and the court's conclusion regarding what the board understood it was being asked to do and what actions the board took.
Mhm.
Additionally, the coalition maintains there was not substantial evidence in the record to make the necessary findings to approve a conditional use permit. And even if there were, the findings of the board were not legally sufficient. And finally, the coalition challenges the adequacy of the public notices of the board adjustment. It's a rather long ruling. It's about 28 pages. I've read it this weekend. And the court ruled that we affirm the district court's decision annulling the writ of certiorari and confirming the board's authority to grant the conditional use to allow the wind turbine. Strike two, you lost twice.
Yeah, I did. I lost that case.
Why should this board be concerned about your opinion when your history in Madison County against the county board of adjustment? Why should we be taking your advice?
Because it's a different
Simply because these two supervisors don't like the advice of County Attorney Pritchard.
Because that's a different set of facts. You don't win every case. If you talk to a lawyer and that lawyer says they never lost a case, they're not telling you the truth. I've been practicing trial law for 54 years. And so I haven't won every case. We took that up. We thought it was in good faith and we lost. Simple as that.
Right. I just feel there's an awful lot of instances where you show up in counties and you make statements regarding winds. You state you're an environmentalist, and but you're always concerned about a host of reasons.
Yeah.
And why would this county believe that you are fair and unbiased in your opinion? I think your history that you've shown through many counties in Iowa is you represent groups. Another one would be the Kossuth County group, the County Citizens for Rural Property Rights, where you represent those groups in opposition to turbines or the ordinance that they're considering. So for that reason, I have questions about your unbiased or fair opinion that we're going to be asked to rule on tomorrow. So you can do what you want. You can follow through with your written opinion and have it to us by 9 o'clock tomorrow. I suppose because we have a majority of the board agreed to hear it and is now paying for it. We should probably put it on the agenda so you can hear, so you can tell us what you think is the best thing to do at tomorrow's hearing. But at tomorrow's hearing, we're expecting a written opinion like you agreed to do. Are you prepared to give us that?
I told you I would. And I told you the reason why I didn't have it this morning. But you disagree with me, that's fine.
No, I just understand.
You'll have it.
That's what we're expecting.
All right.
I just have one question for you. Final question. Are you sure that Worth County will win an appeal, and whether you will guarantee and indemnify Floyd County if we are found liable in the Marble Ridge in a lawsuit?
Absolutely not.
You won't.
No, I won't. You don't guarantee anything.
Sure. Just like you can't guarantee, and no one can guarantee what the outcome might be in the appeals court. Is that correct?
Nobody can guarantee. If you have a lawyer that guarantees you something, you better go to another lawyer.
All right, thank you. There was one other question. Supervisor Jorgensen rose, and I'd like to answer to our legal counsel regarding. Supervisor Jorgensen asked if you believe the 12 exemptions in the Iowa Opens Meeting Law number C that we read earlier is imminent. In fact, what County resident Scott Hines stated at a third reading of the ordinance that he may sue the county if that was imminent, and therefore we need to go into closed session to discuss Scott Hines's statement.
No, I wouldn't take that as imminent. I don't view this as imminent litigation. There's a lot of opportunities, there's a lot of reasons why we don't have to litigate at this point. You know, I think you heard one from Mr. Reveling, that your advice was to negotiate, right? To delay the action of the negotiation. I do think that if we pass the ordinance in its current form, and then we got serious threats from council or representing landowners or something, yeah, then that's eminent. I mean, eminent is it's going to happen. To me, this isn't eminent. This is likely on the path we're on, but there are a lot of things that can change before we're going to have a lawsuit.
All right. Any further comments? Members of the board or the public? I recognize Jim Davis.
Long ago, I got some practical advice from the city attorney. When you're in a hole, stop digging.
Further comments from the board?
I don't know anything.
All right.
I have a question. Were you indicating briefly theater It's reading tomorrow night.
Mr. Rowling can be here, he can be online, whatever he chooses.
Sure. Yeah.
We're gonna hear his written opinion tomorrow. I'll put that on the agenda
Put that on the agenda.
for that. And recommendation that you might want to give this board at that time. We'll also be reviewing our county attorney's recommendation to us. Which
I
we
have a
already
copy
have.
of that.
So it's just a statement, it's just a statement that you made. Yes,
I don't understand why we're not taking our county attorney's advice.
yes, I'm sorry, state the name.
We pay him with our tax dollars. Why are we taking another?
Yeah, state your name for the record, please.
Brett Farmer.
Thank you, Brett.
I don't understand why are we paying a county attorney if we hire another?
Well, that's because these two supervisors wanted to do that, and they are a majority of the board. And they've been expressing their majority rule for quite some time during this process.
And I have a windmill myself, and there's never been a problem. I don't understand the problems. Talk to people that live right beside them. No problem. There's no issue.
My question is, where do these people have to go to their basement to live? I mean, we live on our farm right beside our windmill. We never had to go to our basement to live. Nothing ever affected the animals we had. We had cattle, we had pigs, we had a dog. Nothing ever affected the health of those animals while we had them. So I guess I'm confused at what these health issues are, or are there other underlying circumstances and health issues these people and these animals have?
You know, we hired another attorney because they didn't get the answers that they wanted from Mr. Pritchard. So,
Well, that's my opinion, and clearly we have our attorney at $300 an hour, and we're into him now for 5.5 hours plus.
But if we asked him
Plus
to have
much
something
more.
at 9 o'clock this morning and he didn't provide that,
Well,
I
we
think we need to cut
kind
our
of
ties.
understood that now, and that's kind of beyond this. He'll have another attempt to, given another opportunity to do so tomorrow night. Is there any comments from anyone listening on the phone at this time?
Yes, I would like to comment.
Yes, state your name, please.
Candy Brandall Larson. So we hired an outside attorney for the pipeline. I don't know how this would be any different.
Would you like me to answer that question?
No, I'm asking you why it's different, because you hired an outside attorney for the pipeline. So why is this different?
Okay, we're gonna go back to the July 24th, 2023 Board of Supervisors meeting, so minute meeting, so just pause while I get those out for you. Pull those up from the auditor turn. To start out, we hired Allers and Cooney to help us with drafting an ordinance regarding hazardous CO2 pipelines in Floyd County. We didn't hire them for a second opinion because we didn't agree with County Attorney Pritchard's opinion. He was part of that process. Then, as the minutes will show, thank you, we started down that long road of we actually had one reading of the ordinance, or was it just a public hearing? And on our agenda for July 24th, 2023 was review and action whether to communicate to the Planning and Zoning Commission that pull up that agenda because it's clearly states what our agenda item was. To take review and action regarding directing the Planning and Zoning Commission to cease consideration of that ordinance because of the case in Shelby County, where the district court judge in the Southern District, Judge Rose, had a ruling that, we'll show you what that is. And the board considered that and took review and action on that. Several people were here. And we decided that, I'm going to ask you to go back to the minutes now, after it. All right. Yeah, the agenda item was on July 24, 2023, review action regarding communication with Planning and Zoning Commission to suspend further consideration of the hazardous pipeline ordinance until the case in the Northern District of Iowa is resolved. Now provide me the minutes of that meeting.
Well, that doesn't, my question is why was it okay to go to outside counsel for pipeline and not for wind? In your opinion?
If you just allow me to finish, thank you. I'll make any comment. Here's what we did. The board discussed suspending further consideration of the hazardous liquid pipeline ordinance for two reasons. One, today was the last day, the deadline to file testimony in the Summit Carbon Solutions case. So time has run out to consider a county pipeline ordinance for the Summit docket. And two, and more importantly, the board is aware of Judge Rose's injunction and preliminary decision in the Shelby County case versus Cowser, whereby the injunction filed prevents Shelby County from enforcing its ordinance. So it would be prudent to wait until a judge rules on the two cases already filed into the Northern District, which Floyd County is a part of. And so we stopped consideration of the ordinance at that time, and we haven't taken it up since then because there has been no ruling in the Northern District. So that's the difference, Andy. We hired an attorney to help us with the ordinance, but when it became obvious that there was case law in the Southern District that could cost the county a lot to defend a similar case in the Northern District, and there are already two cases there, why would we go further? So it really isn't the same.
It is the same, and other counties have passed ordinance since then. You just use that as an excuse.
Yeah, the work still goes on in that issue. But we are going ahead, at least it was a unanimous decision of the board at that time, not to go ahead with any further consideration of the carbon dioxide pipeline issue. That's why. Further comments?
Kayla McGregor, can you hear me?
Yes, we can.
I have two questions, Mark. I could not hear the name of, there was a guy and a gal who just spoke prior to Candy. Could you state their names?
That is Brett and Julie Parker.
Carter?
Parker.
Pete. Paul.
Okay. Okay. And then my second question you guys said earlier in the meeting that there's a letter that the wind company sent to the three of you last Thursday at 11:15. Is that a public document or?
Sure. You can release that. They're glad to share that. They're seeking compromise, which is what I'm seeking. And so that's a matter of we're glad to show you that.
Maybe that should be an agenda.
And then I have emailed Gloria 3 different times about getting copies of the maps. So we had it last Tuesday, and on October 9th. Are those going to be public knowledge too? Are those posted anywhere?
I've been busy with the election, but
yeah, definitely.
Zoning department can put those maps up on the website. If I don't get them, I'm busy with election, but Jesse Willetton.
There are maps on the website.
Oh, they are on the website.
I don't know if those are maps you want. There are some there.
Okay. Last time I looked, I've sent emails a couple times, but here not recently. So I'll check again. But thank you for letting me, and I'll email zoning if I can't find them. Thank you.
At tomorrow night's third reading, the walls will be lined with all the maps that we've done, including some new ones that you haven't seen yet. So there'll be plenty of discussion about those additional maps that have been requested. Okay. Further comment, Chair recognizes County Attorney Pritchard.
Thank you. So I just kind of want to clarify, there's questions, you know, why are we hiring outside attorneys, things like this, you know, if you want a difference of opinion, just get two attorneys together. I think, you know, that's kind of an old joke. You know, I've been practicing law for 20 years, and I've been involved in a lot of cases. And just like Mr. Reveling said, anybody who thinks that they guarantee the outcome or know what a court's going to do, get another attorney. And this matter is complicated. But what I want the board to know, and I want the public to know, is that there are some real pitfalls that other counties have fallen into and have maybe avoided or come close to not avoiding, that you all need to understand. And I know this gets complicated. Why is this case different from the pipeline? There are substantive differences that I won't go into, but a good attorney will always ask other outside attorneys, what's going on and what's your take on this, right? Because things are subject to interpretation, and what the court will do. This Worth County case ought to give us pause. It really ought to give us pause. Do I think that the court got everything right? No, there are some things in there that, like I said, I'm surprised with the findings with the vested judgment. That surprised me. I'm not so surprised with her finding of bad faith. You know, and last week when you decide to bring in Mr. Reveling, who I think is giving you good advice to you know, to slow down and attempt to negotiate. Like I said, I also talked to the attorneys who defended Worth County and had a frank conversation with them. I won't go into all the details, but you know, from that conversation with them as well, I think Mr. Reveling's advice is well taken. There's an old saying we have in the Army: don't rush to failure, right? And I don't want to see this board do that. And that's why I've been somewhat vocal with my my statements of caution about what we could potentially be opening up ourselves to. And we don't want to do that. And so I appreciate you coming in on short notice. I understand, Mr. Reveling, you know, you didn't have all the facts. It's hard to come up with an opinion. But, you know, I do appreciate what you're saying, because in some ways I agree. It echoes kind of my concerns in terms of pushing through something that could open us up to a liability. You know, I think it's obvious, the public, a lot of people who are interested here, they want to categorize pro-wind or anti-wind, but really what we need to be is pro-Floyd County, and that's what I'm trying to do. And hope that you would heed that advice. Thank you.
Are you suggesting we table the meeting tomorrow?
No. Any further comments from the board? Questions about tomorrow's agenda? All right, Auditor Coroner will be making that agenda and getting it up as soon as possible, because the meeting starts at 6:30. We have to have an agenda out 24 hours prior to that. So we'll be working on that as soon as this meeting is adjourned. All right. I think we've discussed this issue at length now. And we're at item 13, motion to adjourn.
Also move.
Second.
All right, we have a motion by Supervisor Kiefer, second by George, to adjourn. Those in favor, say aye.
Aye.
Aye. We are adjourned.